Judgment in the matter of Poshteh versus Royal Borough of Kensington and Chelsea.
Lord Carnworth will give the judgment of the court.
The principal issue in this case is whether the appellant should reasonably have accepted a final offer of accommodation made to her under the homeless persons legislation. She had come to the United Kingdom in 2003 as a refugee from Iran, where she had been subject to imprisonment and torture. Her reason for refusing the flat offered to her by the Kensington Council was that the main room had a small round window, which she said reminded her of her prison in Iran and would exacerbate her post-traumatic stress disorder. The reviewing officer did not accept that her refusal was justified. The Council's decision was upheld on appeal by the County Court and by the Court of Appeal, and the Supreme Court unanimously dismisses the appeal in a judgment given by me. Two issues arose in this court. First, whether the reviewing officer had applied the right test and given the adequate reasons. And secondly, a more general issue, whether rights under the homeless persons legislation were civil rights attracting the procedural protection of Article 6 of the European Convention on Human Rights. This raised the question whether the court should depart from its own negative answer to that question in a case called Ali v. Birmingham City Council in 2010, having regard to a later and contrary decision of a chamber of the European Court of Human Rights in Ali v. United Kingdom 2016. On the first point, the decision letter as a whole showed that the officer had fully understood the importance of considering her mental state against the background of her imprisonment in Iran. The issue for him was not her immediate reaction on one short visit, but whether she would reasonably have been expected to cope with living there in the longer term. On that, he was entitled to give weight to the medical evidence submitted by her and consider how far it supported her case. Viewed as a whole, his reasons were adequately expressed. On the second point, there had been a long-running debate on this issue against the background of uncertain Strasbourg jurisprudence. The unanimous judgment of the Supreme Court in Ali v. Birmingham City Council was intended to settle the issue at domestic level after a full review of the Strasbourg authorities. The Chamber in the European case of Ali and the United Kingdom acknowledged the weight to be given to the interpretation of the relevant provisions by the domestic courts, but it did not address the detailed reasoning of this court, nor in particular its concerns over, quotes, judicialization of the welfare services. Although the Supreme Court would normally follow a clear and constant line of Chamber decisions, it's apparent from the Chamber's reasoning that it was consciously going beyond the scope of previous cases. It is appropriate to wait a full consideration by the Grand Chamber before considering whether, and if so how, to modify the domestic position.